So this is Mr. Rojas?
Yes, Your Honor, on page 9.
Okay, everyone else is in. All right, great. So Mr. Rojas is charged with 1 count of misdemeanor domestic battery. Is there a probable cause argument?
No, Your Honor.
Okay, so the court does find probable cause. And let's see, state, what kind of bond are you looking for?
Judge, the state is asking for a $100 bond, no victim contact, and no return to the address.
Defense.
No argument for the $100 bond, Your Honor.
Okay. The court will impose the $100 bond. There'll be no contact with the alleged victim and no return to the residence in the the incident address. The incident address, which I'm going to assume is their home, their residence. Okay. And I think that's it. Let me see, the victim advisor, husband is drunk. Does he have any priors with yeah, just tell me about his priors.
Okay, it was a 2016 trespass with him.
Okay, just a 20. Okay, then I'm fine with this. All right. No victim contact, no return to the residence. Got it. That's it. Next. All right, so Mr. Rojas is done, and then we have Kelly. Who do we have here?
14.
Page 14, Your Honor, mostly.
Okay.
He's approaching.
Kelly Mosley.
Yeah, now you see it.
Hi, sir.
How you doing, man?
Good. You're charged with 1 count of possession with intent to sell, manufacture, or deliver cocaine. 1 count of possession of cannabis over 20 grams, or synthetic over 3 grams, and 1 probation violation, a VOP on a felony for which you're being held no bond. But I do have to impose bonds on counts 1 and 2. So let me hear from the public defender. Is there a probable cause argument on 1 and 2?
Yes, Your Honor. I'm using the PC for the stop. The police report indicates the plates.
Am I getting you on audio?
No, Your Honor, we can't hear.
Yeah, why can't we hear you?
So it's maybe I'm just because I'm not in.
You're not in.
I'm launching. It says let me in.
I don't see you. I'm the host and I co-host and I can't let you in because I don't see you.
Okay. Can someone tell me the room number? Maybe I typed the wrong one.
You must have. Yeah, I'll give it to you. That's strange. Yeah, Zoom number is 62044 6048.
All right. 6024.
No, 62044 6048.
6048. Okay, maybe that's it. All right.
There you are.
I don't know what I was doing.
I don't know either. That's
I
okay.
apologize.
That's quite all right. Okay, there was an argument. The defense has an argument, I believe, on probable cause on counts 1 and 2.
Yes, Your Honor.
I think is that us? Wait, who has to mute themselves? Me? So
It's all that shit bullshit. I'm driving. You can't. She put it mute. She put it mute.
I am mute here.
So Well, I just turned my volume down all the way, so I can still hear your voice, and that way Ms. Lavasier can hear you, and the jail, they can hear you.
Okay,
Okay, that should work, if I can hear you live.
okay, perfect. There was no basis for the stop. The PC indicates it was based on the tags not matching the car. However, there's no indication that there was a crime related to the plates, whether that the car was stolen, whether or not there was going to be some sort of traffic infraction. I've had other judges, and I'm being sincere, find no PC based on stops of this nature. So all the information that came out after this, all the alleged crimes after this are fruit from poisonous tree. So we don't believe there's PC for the stop.
Okay, so you're saying that you've had judges, regardless of if there's PC on the actual, you've had judges find no PC because of the argument of fruit of the poisonous tree?
That there was no crime alleged to warrant the stop. They're saying that the plates didn't match. That is not a crime. They didn't indicate either plate was related to stolen vehicle or that the car was reported stolen. We believe it's pretext.
I get it. I get it.
If the state attorney is speaking, we cannot hear anything that's being said.
Because that is an independent crime of its own that is chargeable, and if he had charged it, I'm not sure what the defense's argument would have been. So for those reasons, the court, obviously, you would still make your arguments if there's a suppression motion in the future. Sure,
Yes, Your
I would
Honor.
expect that. But for purposes of probable cause, the court does find probable cause.
Your Honor is going in and out. We cannot hear anything that's being said on this end. Nothing.
Your Honor, I believe he has a public defender on his other case. We don't believe he can financially afford it. Obviously, if you receive a public defender, you're indigent, we're asking for a reasonable bond.
What's reasonable?
If you're indigent, as low as possible. So if he's already under the supervision of the courts through probation, we believe that there are assurances for the public as he's going to be supervised. So we're asking him be ROR'd to standard
I
pretrial.
don't know what's gonna happen. I mean, he's coming in on a VOP, the judge can hold him no bond or give him a bond if it's not a VFO.
Yes.
What are his prior?
Hey, can I use the phone after they finish with it? They say give me a phone. We can tell them they're gonna give me a phone. I can use the phone.
So, Your Honor, there appears to be a lot of conversation going on, but we cannot hear anything. We cannot, nothing can be heard in regards to this.
The judge's mic is off.
Everybody's mic is off. And I don't know if they can hear me because I've said this like 4 times, but nobody seems to be responding. And I assume they can hear me because I'm not on mute, but nobody seems to be responding. And if I can't hear, I know he can't hear. He can't hear anything that's going on.
Thank you, Your Honor. If we may get a phone number for him, I'm sorry.
I just had to go, I had to put on the record, no bond count.
Thank you, Your Honor. If we can have a phone number for him, so we can at least get money together on those 2 charges.
Can you guys hear me?
Or if Ms. Labossiere can get it.
You guys, they can't hear me. So you guys can't hear me?
Barely. We can hear you a little bit.
Okay, so we haven't been able to hear anything that you guys have been saying this entire time. That's what I've been trying to say. We have no idea what was just said.
Oh,
I at least cannot hear, so I assume that he cannot hear either.
oh, because I turned off.
So I've been trying to do all this, but yeah, we can't hear anything.
Does that include for the prior defendant?
No, so we can hear, so I can hear you now, but just now, everything that you guys were discussing, whatever was happening, we couldn't hear. We can't hear anything.
Weird.
It probably was the echo.
No, maybe.
See, now, no, nothing. And apparently you guys can't hear me either.
I had it on before
Myself.
when I was you heard me make the bond argument.
Yeah, but we couldn't hear anything coming. So anything that came from the judge, anything that came from the state attorney,
I'm
nothing.
muted. Okay, the state attorney. All right, well, you heard the bond, you heard the probable cause argument,
I
right?
did.
Okay, sorry. Okay.
They found there was no pretext that there's probable cause. And you may want to say for the record, Your Honor.
Yeah, okay, just to be clear, the court did find, all right, so let me go back. The court found probable cause, here's why. It is true that the defendant was not charged with all the other charges with an unattached registration or a tag not attached. So, but that is a crime in and of itself. So the state has argued, I didn't know if this was heard or not, but the state argued and the court accepted the state's argument that that is a crime in and of itself. And therefore it is that is probable cause for the police officer to pull over the defendant and if appropriate, conduct a search. So that's the state's argument. So even though that crime was not separately charged with the probable cause affidavit, the court does find probable cause for the crimes that are charged. And I'm specifically talking, of course, about counts 1 and 2. So the court did that. And then the argument was of bond was that Ms. Shaw asked me to continue the standard bonds of 2,500 count 1 and 1,000 count 2. And then we heard your argument about that. Oh, no, we heard your argument that we had Ms. Drake's argument that he is a public defender client, right? Thank you. What am I hearing? Somewhere in the jail. We heard that. Yeah, thanks, guys. We heard the public defender argued that he's a public defender client and the bond should be as low and as reasonable as possible. The court considered a prior criminal history of the defendant, including, and I'll have you stated on the record one more time, Ms. Shaw, I mean, for the 3rd time now.
Ms. Labossiere, can you just confirm for me that you can hear me?
Yeah.
Okay.
Is that a yes? Sorry. Okay.
She needs to say it loud.
Okay, in 2019, he had a possession of controlled substances without prescription, 4 counts adjudicated. He also had a 2019 DV case. It looks like it was a civil DV case. And the other cases, other charges are all past the 10 years.
Right. And so based on the prior criminal history, the court decided, considering everything, to reduce the bond on count one or the suggested bond to $1,000. And as indicated, count two, $1,000 for a total of $2,000. That's a straight bond with no other conditions, just the bond itself, of course, and to return to court. And he'll be held, continue to be held, no bond on count three. Okay. Oh, we got another long one. We had to wait till the end for this.
Number, Ms. Drake?
1 second.
I can't hear it.
Did you say something, Ms. Labossiere?
Yeah, did you need a phone number? Because if he needs to provide his phone number, then he should do so now.
Okay, you can get it. I can get it. It doesn't matter.
Okay. Can you state your phone number? Can they unmute him?
I think he has court on the 11th.
Okay, so he'll be back in.
That'll be fine.
Okay, then that should be fine. Yeah, because I mean, he'll be held, so you'll be held no bond until they can address it on the 11th, and you should have a PD then.
754-816-0803.
Thank you.
Okay.
I'm just letting my husband know that I'm still in court. He's probably wondering. That's how he calls. So thanks everybody for waiting. All right. Are we good now? Are we finished with
Your Honor.
defendant? That's Mr. Mosley. Are we finished with Mr. Mosley? Everyone do public defender?
Yep.
We got one more.
One more.
Yeah, I'm heading there right now. Give me 3 minutes.
Okay, sir.
It's 7, Your Honor.
Who is the person?
7. Kitra the bond.
Chitra Thabon. We'll ask her to pronounce it for us.
Yes.
Yeah, right? I thought at this hour. Oh, you mean, oh, I totally forgot. I'm sorry. Oh.
Ms. Labossiere, I'm gonna ask for a number for her to post bond. So if we can get a number, if I forget.
Okay, she's got 2 VOPs.
I know.
Okay,
Thank you.
no problem. She did give me a number to her husband already too, if you want that.
As long as you have it, we can talk afterwards, just while we were waiting.
Okay, sounds good. Thanks.
Yeah.
You're so chipper, Miss Labossiere.
That is a consistent? Yes, yes. I do. I am typically generally very perky.
That's good. It's a great demeanor to have.
I prescribe to it's all everything in good faith. I go for the event. I try to keep it in good demeanor, good context. Can't make it worse. So
Yeah, I know, especially right with what you do. You're not really delivering the best news. So, you know,
exactly.
you make the delivery as pleasant as possible. Okay, I think I did it all. That was like 2 hours later. Okay. All right, so still waiting. What were you saying?
Hey, Yana, we got,
Ah, there she is.
Sabon.
What, had you not been, oh, you couldn't come in? Now you just
My
were,
internet was acting up.
okay. I didn't know that was your first name.
Yes.
Okay. All right. So now we're here. Last but not least, Ms. Chitra Thaban. Why don't you, I wonder if I'm going to have reverb, but I'll ask her. Ma'am, how do you say your name?
You said it correct, Your Honor.
Thaban?
I'm sorry, Taboon.
Taboon. Taboon. Chitra, I got.
Yes.
Okay. So you're muted, so I should be okay. All right, good. So I'm going to recite the charges. You're charged with several counts, ma'am, which are as follows. Count 1, failure to redeliver a hired vehicle. Count 2, driving while license suspended, second offense. 3, false ID given to law enforcement. Count 4 is a capias on a felony, I guess. Are those warrants?
Yes, Your Honor.
Felony warrants or felony capiases, one of them. Okay. On counts 4 and 5, for which you're being held no bond by the divisional judge per order. Count 6, grand theft, 10,000 or more, less than 20. Count 7, fraud, attempt to use the ID of another person without consent. And also count 5 is a VOP hold by the division judge. You got a no bond hold. So no bond hold on 5. Wait, I think there was more. Is that it?
I have that for count 8 and 9, Your Honor.
And 9, and also for 9 is a no bond hold. Okay, so I'm going to address the bondable offenses. So let me scratch through, right? No bond, no bond. All right, the bondable offenses are 1, 2, 3, and 6 and 7. I think I got it. Okay. Is there a probable cause argument?
No, Your Honor.
Okay, so the court does find probable cause on counts 1, 2, well, on all counts. So the court will indicate that. And then state, what is the request for bond on the counts for which a bond is available?
Okay, Judge, for the bond, the state is asking for $1,000 on count 1. For count 6 and 7, the $1,000.
Okay. One's in set forth.
And Judge, for 2 and 3, the state will be asking for the
50. On 2 and 3, and then 4, 5, 8, 9. I think that covers it, right, everyone?
Yes.
Okay. So you're asking $50 per?
Yes, Judge, sorry.
Okay, got it. So $100 in addition. So 1, 2, 3, $3,000, $5,100. Did I do that math right?
It would be
No,
$3,000.
$3,100. I apologize. Okay. Who's going to argue for the defense?
I will, Your Honor. And do you want to mute while I go? Okay. Ms. Sabon has been represented by the public defender for her several cases, meaning she is indigent. She cannot financially afford an exorbitant bond. All of her offenses are nonviolent. She does have pending time left on her probation cases, so she will be supervised in the community. We believe that the supervision of probation and in a reasonable pretrial release, if the court's inclined, would be sufficient to ensure that she comes to court. It's unclear if these cases are for failure to appear, if they're related to the no bond hold. We're asking that she be released ROR into standard pretrial release.
The state attorney cannot be heard, Your Honor. No, you need to unmute.
I need to unmute?
Me? Okay, is this better?
State attorney, yeah.
Okay.
Okay,
Yeah.
okay. For case 2017, in light of the, I'm sorry, in
Wait,
light of the
hold on.
prior.
Just stop a second. Let me see something. I'm trying to figure out how to stop the reverb. If I mute, let me know if you can hear me. Okay, can you hear me now?
I didn't hear you, but we need to hear the state attorney. If you guys can go back.
So you talk now.
Okay.
Let's see.
Okay, can you hear me now?
Yes, perfect.
Okay, Judge, in light of the priors, the state would be asking that the bonds requested be held. There are a 2017 and no valid driver's license, withhold of adjudication, a 2014 grand theft adjudication, a 2012 failure to redeliver leased property adjudication, false use of ID adjudication, and a no valid driver's license adjudication, which is similar to the offenses currently in this case.
Quite similar. Okay, hold on a second. I see these capiouses, because the defense, oh, wait. Sorry. Okay, and you're gonna mute now. Okay, I see it was highlighted as to what the capiouses were by Ms. Blake, so I looked through my packet that I have so it could be made clear. One is a no-show. And these are FK in front of Judge Siegel. Probably, let me see if it says the same date. Probably, it's different, yeah, different cases. Okay, and then let me be clear that the capiouses have preset bonds on them. So the capious, these are not in custody capiouses on counts 1 and 2, which I just got to make sure that I'm clear on which ones they pertain to, because it's the grand theft. So it's 1 and 2 actually pertain to, if I look at the case number, 6 and 7. So those bonds are preset on 6 and 7 per the capious. All right. So that's going to stay. I'm looking for, hold on, wait, count criminal use of personal information. Wait, where was that one? Grand theft, fraud. Yes, that's 7. Wait, 1 and 2. 1 and 2. 1 and 2. The information. Wow, this is a little difficult. Yeah, no, that's right, because I'm looking at the case numbers. Okay, so that's correct. All right, so those are how those are charged. And then I guess the only question, or the question that I have is, I'm not sure how if those other ones are not charged in the information state. Does that make sense? I don't see a charge or a capious for failure to redeliver hired vehicle, and I don't see an associated case number.
Okay, so for, I don't know if I can mute real quick.
You
So
unmute.
for the counts 1 through 3, these are new. So the officers bring her in on these counts. So they saw that the vehicle was registered stolen. They waited for the individuals to get back in the vehicle, started driving, and they were leaving the Coral Square Mall, and then they picked them up.
I see it as you're talking, right, oh, sorry. Yeah, as you're talking about it, I understand now.
Gotcha, Judge.
All right, so based on that, the court will, the bonds that are assigned to counts 6 and 7 will remain. The court also notes the prior criminal history with a lot of the same types of offenses. So the court will impose the $1,000 bond on count 1 as well. So the bond will be, as requested, the suggestion of the state attorney is adopted. And so counts 1, 6, and 7 will remain at $1,000 per, and counts 2 and 3 will be $50 per. Okay, so that's a total of $3,100. The defendant shall be, we have failures to appear. I don't know if she had bonds on those. I'll leave that to the division judge. He's got no bond holds. So he can decide if there are going to be release conditions associated with that based on failures to appear in the VOP cases. Makes sense. So the court will impose just a straight bond. And then are there no issues about no return victims? What will we do in this case?
So Judge,
You're muted.
Yes, I apologize, Judge. So the state would be asking for the defendant to not return to the Fox rent-a-car, as well as,
Okay.
that's it, just to not return to the Fox rent-a-car company.
Okay, that's so ordered. No return to Fox Rent-A-Car Company. Okay. I think we're done. Could it be?
Are we?
Everyone magistrate on Monday, they'll find us all here.
Thank you, Ms. Lavoisier. I think we're good.
Thank you, Ms. Lavoisier, for your perky mood, especially at 10 minutes to 3.
Right?
Past lunchtime. Kind of like the intermezzo. All right, anyway, thank you all.